Okay, good morning, everyone. We're going to get started with our policy meeting for the Sentencing Commission. We have some folks here in person, and we'll check to see if we have anyone online as well. Present is myself, Representative Rick Krajewski, the Vice Chair. We have the Chair, Chair Bernstein. We have Judge Marsico is here. I see his stuff's here. Judge McDermott, Professor Rago. We also have our acting secretary of the DOC, Laurel Harry, and have I missed anyone else? That's everyone. And then do we have any members online?
We have Attorney Marsico and Representative Bonner.
Okay, all right. Thank you, members, for joining us. And with that, I will pass it over to Mark to kick off the meeting. Thank you.
Great. Thank you, Mr. Chairman, and good morning, everyone. You may recall that yesterday we spent some time reviewing three proposals before the commission or before the public to review the comments we received during the 6 public hearings. And we spent a lot of time on reviewing the sentencing guidelines or the proposed sentencing guidelines and reviewing suggestions, making changes, and so forth. So what we're going to present or show online and what we, I believe, have distributed to members is a sort of a printer's draft of the modifications or changes to what we published a couple months ago. And so as soon as that's up, we'll just sort of go through this for a couple of reasons. First, to make sure that we've captured correctly the decisions that were made yesterday during the discussions. Secondly, in those areas where there's maybe not a final decision on wording and other things like that, we have a chance to revisit that and to sort of lock down those things. And then the third, I noticed at least 1 or 2 suggestions that were made during public hearings that were in the markup, but that I sort of passed over as we were covering everything else. So I want to make sure that I'll at least bring that to your attention so that you can make a decision on that issue before we move forward. So with that, we're going to do what we did yesterday. We're going to just sort of walk through the document. And anytime you see something in bold, it means, or almost anytime you see something in bold, it means there was a change. If it's in brackets, it's removed. And if it's underlined, it's added. So the first thing is the addition of the definition of administrative probation. The intent here is that at level A of the guidelines, where the recommendation is limited to restorative sanctions and in particular fines, restitution, and community service, or guilt without further penalty. We talked about in some counties, there's an interest in having a mechanism to either implement the order or at least monitor compliance. And so this is the definition we came up with, that really, the focus is not to have supervision of the case, but rather just whatever is necessary and only necessary to promote restitution, fines, community service. So let me turn it to the chair to make sure this captures or any kind of changes to this before we move forward.
Thank you, Mark. Any members have any thoughts or agreement with the current working definition? And I think the addition was the only section, right?
That's correct.
Does that feel? Oh.
No, I just want to say, I think it makes a big difference. And I think we'll talk about it more when we talk about if there's a resentencing because of a violation.
Right. But it is just a little bit different than what we talked about yesterday. I know Judge Marsico suggested putting in the only when necessary or only that necessary, only that necessary to monitor compliance. And then we had supervision. Well, I guess we still do have supervision there, but we had listed, I think, sort of broad conditions, and this limits it to the 3 we talked about. So, okay, great. Then we'll move forward with that. Continuing to go through the document. This is just the changing SGS Web to the more generic commission sentencing guideline application. So you'll see that throughout the document. This is the removal of the reference to REVOC, because that really doesn't capture prior record score 4 anymore, and so it's not really necessary for these guidelines. And then I modified the definition of restorative sanctions to fit what we discussed. And then I tried to just make sure we were consistently listing the order of these. So restitution, fines, community service, and then administrative probation. Yeah, this is just correcting the reference to SGS Web. This takes into account some of the comments we received about fines. So we make sure we add the reference to the other section of statute and make sure we include reference to the defendant's ability to pay. And then under restitution, providing sort of both clauses, either the direct sentence of restitution or restitution as a condition of probation. And then we add as a restorative sanction administrative probation, and we remove any reference to costs and fees as part of a restorative sanction, that is a separate issue that courts can address without the assistance of the guidelines. And so one of the things Ron and I discussed was, if we're thinking about these three types of probation: administrative probation, say general probation, and probation with restrictive conditions, we should probably call probation general probation when we're at least within this context. So while the statute provides for an order of probation, we're effectively discussing three different types of probation. And so that is just a clarification of that.
Mark, just one
Sure.
quick question on, so I know we took out the cost, but then I see there's still section E, fees. That's fees related to, yeah, can you explain that section?
Sure. So if you look at statute, and as the testifier from the ACLU mentioned, in statute, there's a lot of words used to refer to costs, like fees and other things like that. But they're all effectively costs. So in the guidelines, because in statute they use different labels, cost versus fees, we broke that out in the proposal. But since I think it was agreed that they're all effectively costs, we took out both costs and fees. Okay, Ryan. Okay. And then this is just some high level references to how the process works. And this is where we start to try to focus on the distinction between offense specific recommendations and whatever we're going to call the stuff in the judicial proceeding. But I think yesterday I was using the term label. I mean, the label benchmark. I have another suggestion, and you'll see it down at the bottom of the page, voluntary standards. And standards seemed like too formal. But when we look at the research or the discussion of like sentencing guidelines, they talk about like the continuum of guidelines. At the far end are voluntary guidelines, and that the other end are presumptive guidelines or mandatories. So we have what are considered advisory guidelines, but I think to the beyond us are probably the label voluntary is used. So I think that might capture what we're talking about in terms of that starting point, or that consideration for the court, where it's not part of the guidelines but separate. So at least at this point, and we can come back to it when we get to the end where we deal with judicial proceedings, I plugged in the term voluntary standards. So we'll get to that later. And then here's just reference to SGS Web. And then this was a typo in the first one where we had 6 categories for murder rather than 8. So that's the correction. Okay, this is including inchoates with the domestic violence enhancements. So we just added an attempt, solicitation, conspiracy to commit any of these. and this is the section regarding the child pornography enhancement that was added by statute and added in Table C, but I forgot to add in the text, so that's inserting that in. So this is going to look really busy, and part of it is just formatting. As part of the prior record score, we came up with this concept of these prior offense groups, POG. And in the prior record score section, sort of in the middle of the section, we defined what the four categories were. But because of the changes we're making to lapsing and things like that, juvenile adjudications, we really needed to define those things up front. So I basically took the stuff that was later in the section and pushed it up front so that we're starting off by defining the four POG categories, and then we can use reference to the categories throughout the rest of the section. So it just sort of flows a little bit better. So there's no change here. It's just a text change in terms of moving it. And then as we move down through, here's the suggested language to first capture which offenses are considered when looking at prior juvenile adjudications. So as you'll see, the top bold stuff in the brackets is what exists right now. So we just say the person is 16 years of age or older at the time of the offense, and there's an express finding that it was a felony or a misdemeanor first degree. That's what we have in the proposal. And you'll see right below that the change is to first create a category that's 14 and 15-year-olds, so 14 years of age, but less than 16 years of age, for which there's an express finding for a crime of violence, so the POG 4 category. And then the second category is everyone else, so person 16 years of age or older. And then if you recall, we were trying to limit misdemeanor ones to those that were really serious misdemeanor ones, and other misdemeanor ones would be excluded from consideration. So the language used was that it would be POG 2 or 3, because POG 4 is taken care of in the first clause, and POG 1 would not be considered in juvenile adjudication. So I think this captures what we talked about. And then here we get into, this is where we were just removing or moving these definitions up to the front. So that's just a way of getting rid of them. And then we talked about removing the burden of proof for lapsing from the defense. So that is removing the language. Then as we move down, we get to the policy regarding juvenile lapsing. And so I think where we arrived, and I guess we can continue to discuss this, but the first is that the only issue regarding the 10-year crime-free period relates to two categories. One is that new category of, first is removing the adjudications in the POG 3 offense list. So misdemeanors and felonies as listed before. And then the second is removing those crimes of violence that were committed by 14 or 15-year-olds. So this is, I think, consistent with what we talked about yesterday. So again, for a 10-year crime-free period, there's two categories. One would, and both of these are from the lapsing period starts at the last adjudication or conviction. And so these are the two categories.
Okay. Thank you, Mark. Good morning, Jay Sunday. Just joined. Probably good to stop here and make sure everyone's good with this language. Good. They'll give you some time to get settled. Good morning.
Still using prior record score and POG both?
So I know it sounds a little complicated, but POG just defines the four categories of offenses. So crime of violence being 4, which is the most serious, and 1 being other misdemeanors. So there are 4 categories of priors. And then to get to the prior record score, in some cases, it's just 1 offense from the most serious category. In some cases, it's 2 or 3 offenses from the most serious category. And in fact, we have let me show you the reference. Actually, we'll get to it in a minute. As we page down through this, we'll get to the section where it defines how POGs relate to prior record
And do
score.
we define POG somewhere?
We do, up at the top. That's the part that I just, if you could page up, Ryan. This is the part that I sort of moved around. So here at the start, a little bit higher. There you go.
Okay, gotcha.
Actually higher than that. Let's go back to it. There we go. Right there. Okay. So a little bit down, so we can start. Okay. So prior offense for prior offense groups, POG, distinguish seriousness, et cetera, as described below. And then we have below the 4 categories: POG 1, POG 2, POG 3, and POG 4.
Because you just know how people are going to be. We're so used to PRS, prior record score.
We are, and we're going to, I mean, we continue to use prior record score, but it's just, so what the policy says is, at the time of sentencing, you look back at all prior convictions and adjudications prior to the date of the offense. And you identify the most serious offense, and then you identify how many offenses are of equal seriousness, and that's the POG group. So if you look back and there's 2 crimes of violence, that means there were 2 prior convictions or adjudications for a POG 4 offense. And then when we get to prior record score, we say you need to have 2 POG 4 offenses to be in prior record score 4. So we still have prior record score in the guidelines and the matrix. It's just a way of, instead of having all this language about, oh, it's like these misdemeanors or these felonies or whatever else, we just come up with a category, 4 categories. And the other thing is that makes it easier. You know, one of the things we struggled with early on was, if someone has a prior, felony 1 offense and a prior felony 2 offense, and they're both sort of in the same category, and you say, well, look back and identify the most serious offense and an offense of equal seriousness, or any offense of equal seriousness, some would take that as, oh, just other felony 1 offense or other felony 1 offenses with the same OGS. So this puts them in 4 categories. Thanks. Okay.
Thank you, Mark. And then,
Oh.
yeah,
Just
Yes,
real quick, I
Sure.
wanted to apologize for my tardiness. My son's bus comes at 8:30, so it takes 44 minutes from the bus stop to get up here. And so in the real quick, so far in the numberless page
Yeah,
numberless
I know.
document.
We wanted to keep you on your toes this
Yeah,
morning.
so I just want to make sure. So you've gone through up to
We have
POG
we're-
1, 2, and 3.
right. That's
Okay.
exactly it. Yep.
Okay,
POG 1, 2, 3, and 4.
got it.
So,
Thank you.
got it.
I appreciate
You
it.
bet.
Thank you.
Sorry. So let's see. So this is the,
you're just assuming everyone's good. Is everyone good with this language regarding the juvenile adjudications?
yeah, this would, right. So this is just the definition of what we count in juvenile adjudications. Then I think we were at the lapsing stuff. So a little bit. There you go. Right there. So so this gets to that 10-year crime-free period, and there's now 2 categories. One that addresses POG 3. Thank you. One that addresses the POG 3 offenses, and the other that addresses the POG 4 offenses for 14 and 15 years of age. And then down below that, you'll see that the 15-year crime-free period is limited to those POG 4, those crimes of violence by persons 16 years of age or older. So that's the distinction that we talked about yesterday about like the 2 different categories of juvenile adjudication. All right. And then just if you could just, let's stop right there. So one thing that I had in the materials yesterday and I overlooked, so I just wanted to bring it to your attention in case there was an interest in making a change. Some of the feedback we received regarding adult convictions dealt with the look back period or the lapsing period for adult convictions. And one issue that was raised consistently was whether the first category for adult lapsing that deals with POG 1, which is just misdemeanor offenses that aren't any of those serious misdemeanor 1 offenses, if that lapsing period should be reduced from 15 years to 10 years. And it's more first, it took into account that the most serious offense you could have there is a misdemeanor 1 offense that has a 5-year period. So you basically double the statutory max for the look back period. And also it's more in line with the clean slate legislation and other things like that. So the suggestion was in this section for 3I, that we would change that from 15 years to 10 years, and then 15 years of crime free, which is gap for when you get to POG 2 and 3, and then a longer period for POG 4. So
Thoughts from members about that change from 15 to 10 for POG 1 offenses? Judge McDermott?
I think we touched upon it indirectly yesterday when we were talking about other issues, trying to get more consistent with clean slate. So I think we should be consistent. And and I think the rationale makes sense. We're doubling the year for the statutory max. So I would be in favor of it.
Any other members?
And I think we did discuss yesterday that this also reflects the common understanding based on data studies with regard to whether or not a juvenile offender would continue to commit crimes of violence. Obviously, we took into consideration public safety in coming up with this, because essentially, I mean, so with regard to a crime of violence, let's say we'll say you're 16, right?
Mhm.
And you commit a robbery. So what would that juvenile have to do so that robbery, at what point would that robbery no longer count as in their prior record score?
yeah, if we can back up just a little bit. So this is about juvenile adjudications, the question you're raising, and the clause we have is a crime of violence would be POG 4. That's the
Mhm.
category. So if someone's 14 or 15 years of age when they committed that offense, the look back period would be 10 years crime free since the last adjudication or conviction. And then when we get to someone 16 years of age or older for juvenile adjudication, that would be 15 years crime free since the last adjudication or conviction.
And that obviously also takes into I mean, that's a long period of time.
It is.
And we're also discussing
And it's crime free.
crime free.
Right.
I mean, so there's an incentive there to be crime free as well.
Absolutely.
And in addition to that, this also puts, but there's also an understanding clearly that those adjudications don't go away. This is
Right.
solely for prior record score.
That's exactly it. And courts can always consider factors. In fact,
Yep.
courts can consider sealed juvenile
Exactly.
records.
Exactly.
It's just not built into the calculation of the prior record score.
And it also provides, again, an incentive to be crime free.
That's right. Yep. Thank you.
Thank you.
Sure. So then moving down to the adult convictions, this is what we just talked about in terms of reducing the 15 years down to 10 years, sort of mapping clean slate and others. So if there's no objections, we'll include that as a change in the draft. Okay, and then we'll keep moving along. This removing the reference to Reebok, and then I don't know what else this is. One of the things we talked about yesterday, and we need to go into detail, and we'll look at the matrix to just capture this. But for prior record score 4, in the past from level D up, so once you get into basically state incarceration up, there would be the range for prior record score 4 would always include the statutory limit, the longest minimum sentence possible. And there was, I think, concern raised during public hearings that for the lowest category of confinement in a state facility, it might make sense to have a shorter range, that it doesn't include the statutory limit. And I think that was, that made sense. And so we have in the matrix draft that we'll put up next, we have some changes to that, and I'll just read through the what the changes would be. So this is level level D of the sentencing guidelines, these are state confinements with a county exception. So think about in the old days, this would be the 2 to 5 year sentences that could be served in a county jail or in state prison. And so that's what the level D category is. And so over at the prior record score 4, for OGS 9, we presently have it as 12 to the statutory limit. And what we changed this to is 12 to 18 months. For 10, it was 16 to the statutory limit. We changed it to 16 to 22 months. For 11, 20 to the statutory limit, we changed it to 20 to 26 months. And 12, we had 24 to the statutory limit. This would be 24 to less than 30. And can you blow that up? Yeah. So if you sort of look at this, there's sort of a stair step thing. So if you look at the previous, yeah, there you go. And look at that. So we just paralleled that and shifted that over, which is sort of the practice we have for most prior record score builds. And then above that, we'll retain the statutory limit as the upper end of that range. So, okay, back to the document. So that's why in the document, we changed the reference from level D to level E. All right, we'll continue to move through this. So this is where, this was just removing that word benchmark because I was thinking of using it somewhere else, and then just inserting framework, and which I think is not much. And then down at the bottom, we just removed reference to that part because that dealt with the proposals we had last year that we decided not to proceed with. And then under 2, we've just removed that section that deals with those general guidelines on judicial proceedings. So these are just sort of textual things. Inserting offense specific to make it clear that these are the guidelines. And then we talked yesterday, Professor Rago talked about the autism spectrum and things like that. And Ryan did some research, and there's a broader category that includes autism spectrum, and that's the term developmental disorders or disabilities. So we use that sort of consistently when we're talking about behavioral health or treatment. We use that phrase, and you may recall that one of the enhancements we have, one of the more recent enhancements, does deal with autism or the autism spectrum. So in the definition section, we do have a definition of autism, so or the spectrum. So so this all ties together. I think this works pretty well. Throughout this section where we're talking about offense specific recommendations, I tried to get away from using the word encourage because we use the encourage when we're talking about the general stuff at the back. So I just switched all the encourages to recommend. And then here for level A, again, trying to be consistent in sort of the order of economic sanction or restorative sanction. So restitution, fines, community service. And then putting in sort of that caveat about limited to administrative probation if you're going to use probation at all. This gets to the fine of being, it just sort of echoes what we talked about before in terms of the use of administrative probation. And also, I think in here, we plugged in the reference to the defendant's ability to pay related to a fine. And then under restitution, we put in the sort of 2 different ways, the direct sentence and the condition of, in this case, administrative probation, and also just for the condition of probation part, the consideration of ability to pay. So that's consistent with the testimony and with what we discussed yesterday. We got rid of costs. And then here's where we labeled probation as administrative probation for this level, and you'll see later we label general probation for the other. And again, changing encourage to recommend. So for the ag MIT, this is where we extended or expanded the duration of the ag MIT ranges for level D from 4 months to 6 months and level E 6 months to 9 months. And then in the example, we just corrected the example with the new duration. The same. So these were the aggravated ones. The same applies to the mitigated. And then we talked about just clarifying the language about the reporting first, the consideration, stating on the record and reporting to the commission the reasons, and then separate from that, the court considering but not limited to various reasons. So that's just what we discussed. And then moving down.
Mark, quick question. I apologize. Just to go back to this. This is just for my clarification for
Sure.
me. Under the section where it says the guidelines recommend consideration of the use of restorative sanctions, including restitution, fines, community service.
Mhm.
Previously, it's said economic sanctions.
Right.
And so removing economic sanctions and replacing it essentially with restitution and fines is a way to further delineate what economic sanctions actually mean. Is that correct?
That's correct. And also to remove from it the previous reference we had to costs and fees.
Okay.
And then I think one of the issues you raised before was victim compensation. And I was trying to look at the language in the victim comp statute and look through anything I could find. I think we're in good shape, but staff will go back and look at that more closely or contact PCCD about the victim comp. I think it's considered restitution in statute, that it's a mandatory sentence, but at least in what's posted online, I couldn't find a clean thing, and I want to look at the statute.
And I certainly defer to your expertise in that area. I just want to make sure it's clear
Sure.
that I would not want to see anything in the guidelines and the proposed guidelines negatively impact any verbiage that's statutorily mandated with regard to victim restitution.
Absolutely. Well, absolutely. This will not impact victim restitution. The concern, and it's, it's pretty tedious, but so here's the thing. The discussion yesterday about cost and fees was basically a discussion around, courts must order that. It's mandatory, or there's all kinds of prescriptions about that. It's just, does the commission recommend it as a sanction, as a sentencing option, or is it actually a reimbursement that the court's just doing as like a collateral consequence? So it's not that we're saying don't do it. We're just saying we don't have really any authority here, so we might as well not plug it in. And we probably shouldn't put it under the label restorative sanctions because, as I think the ACLU said, it's neither restorative nor a sanction, it's a reimbursement. And so that's why we'll figure out about victim comp fee or whatever the label is for it. I think it's considered restitution, but if it's considered a cost, then it has to be ordered anyhow. Anything we put in the guidelines isn't going to take away from that mandate.
I know it's nuanced.
Yeah.
And so I appreciate that. Thank you.
But sure, absolutely.
Mark, can I jump in here?
Yeah.
'Cause it's been a while since I looked at a detailed analysis after I imposed a sentence. But I actually think in the mandatory court cost and fines, it is a distinction between restitution and victims comp. Because it's done automatically. The payments that individuals make are apportioned. And I know it's been an issue with judges over the years that restitution is not given a priority, but we have been told repeatedly, this is a statewide, not a mandate, but it's a statewide, I guess, assessment and collection. But I do believe, and I see some nods of heads, it is a distinct category from restitution.
I think it is, but like I said yesterday, we did some research on this a long time ago, and you're right, it's just something a bit different. And I think I sort of recall a person can't be released from DOC or paroled until that fee is paid. And then I think there was a mechanism to make sure it was paid so that people could be released. Is that correct, Secretary?
Yes, it's automatically part of, he's correct. It's automatically part of, each inmate's release and it's designated for.
Got it. Okay. And is that, Deb, was there there like a fund or something? Because I thought people were being held from parole because they hadn't paid that fee. And I thought there was some mechanism in place to make sure funding was available to pay that fee. Okay. Yeah. Got it. Okay, great. Well, anyhow, we'll look into it. We don't want any of the changes made to impact that in a negative way, but it is sort of, yeah, there's some nuance there we have to get to, I guess. So otherwise we're removing costs. So here we go. Let's keep going through. So we talked about adding or modifying 2 reasons for a sentence. So, and I think there was some, I guess not. Okay. No, I'm something else. So when we get down to, we added the multiple offenses in a criminal incident. And then at the bottom of that, we added the treatment for substance abuse, behavioral health issues, or developmental disorders or disability. So those are in as reasons. And then here's where we did the sort of the rewrite to capture to more effectively distinguish offense-specific recommendations from these more general standards. So I listed it as voluntary standards, and so the change here is just trying to incorporate that. And then you'll see that throughout this, we rely on the word encourages. So we're encouraging judges to consider. These are encouraging practices that promote that kind of stuff to really distinguish offense-specific recommendations that are subject to review and conformity to the guidelines and all that kind of stuff from these more general voluntary standards as like a starting point. So we can go down through and you can see that where it fits into the text. So here's just some language where we're just trying to more focus on the encourage to consider language. And then here's where we also, when we were talking about the exceptions to concurrent sentencing, we talked about expanding the section that deals with crimes of violence and including language that addresses convictions for sexual assault, domestic violence, and involving vulnerable victims. And then down under 3, you'll see the addition of multiple criminal incidents in addition to the multiple crime victims, and then circumstances for which a longer sentence is warranted to address treatment needs. I think we discussed all of those yesterday, so that's how we plug them into the guidelines. And I think we're about done. I think the other is just conforming the text. Yeah, court encouraged to consider. So that's it. Yes, Judge.
I'm sorry, Mark.
Oh, no.
Did we briefly touch upon yesterday, or maybe I missed it, that we might discuss other language to replace the word decay when we're talking about, the look back period, or was that my
I don't
imagination?
I mean, maybe up there you talked about it. Down here with the
Okay.
folks, I don't recall talking about
Okay,
that.
well,
We
I
did.
thought it was a reference that we might be
Yeah.
changing some
Yeah, and-
language, and I thought decay was in that. It's just, I don't know how other people feel.
Yeah.
That word, I don't know
Yeah.
where it came from.
not-
I'd
well,
like to
yeah.
know.
I'll give you a little background. So there's people that talk and think about sentencing stuff and make up words and terms, and so one of the sort of think tanks around sentencing issues and guidelines is the Robina Institute at the University of Minnesota Law School, and they've for a long time been doing a lot of work around prior record score and looking at practices around the country. And I'm going to attribute to them, but they might have gotten it from someone else. But they've come up with these 2 categories because they needed a term to define the difference between looking at law-abiding behavior as a prerequisite for lapsing and just having time run. So, our DUI statute, the look-back period is decay. But yeah, I don't think I would have picked decay as the word, but it's something that's used sort of commonly in the field. So we appropriated it into the guidelines.
Yeah, well, thanks for
Yeah.
educating
We-
me.
we can
It just,
blame them too.
every time I see it,
I know.
I have a visceral reaction.
Yeah.
And it's like, I don't want
Yeah.
sentencing guidelines associated with, this
I know.
withering, decompensating. Okay, am I the only one that? reacts?
No, it's, yeah, I mean, it's,
You know, I agree
Blame
with,
that.
I agree with you, Judge, completely.
yeah.
And hopefully you'll remember that when we discuss F3s a little later.
Oh, come on, I'm going to compliment you on all the good work you've done with those F3s.
Okay, so I think that if
Before we move
unless-
on, Mark, I know
yeah, sure.
we talked about this in Pittsburgh. Thing. Somebody brought up about for the lists of reasons for
Yep,
departing plea negotiation.
Yeah.
And
Okay,
you have
yeah.
a reason as to why we didn't, because to me, that's the most common one I see.
Yeah.
As to why there's going to be a departure from the guidelines.
Sure.
Especially downward.
Yeah, that's so. Thanks, Judge, for raising that because we did talk about it in Pittsburgh, and you're right. When we look at reasons reported for sentencing, plea negotiation or some phrase similar to that is used. That's the most common. But what we were trying to get at with the list of reasons was to help as sort of a feedback loop to the commission about should we be changing the guidelines. Like when we look at conformity to the guidelines and we see that there's a lot of sentences below the guidelines or above the guidelines, one mechanism that the commission can do is look at the reasons provided to say, oh, judges are doing this because of, and then maybe we subcategorize the offense or we change the OGS assignment or something like that. But we have like a basis for doing it. And we ran into that with Murder 3. Like with Murder 3, we talked about there's probation and there's 240 months, and everything in between. But we have no idea. I mean, we have some ideas about why it's happening, but not in any kind of systematic or consistent way. So if the concern is if we put plea negotiation in as a reason, it'll be used a lot and it won't tell us anything about like what's the reason for doing this, except that the parties agreed and it was, in the interest of justice or whatever else. So anyhow, we can certainly add it and it's certainly used a lot, but it really doesn't like advance the ball much for us. The other thing I will mention that in our data, we do try to capture, I think that the nature of the disposition or whatever, I forget what we call it, but we try to see if it was an open plea, a plea to the sentence, a jury trial, bench trial, things like that. So we do try to get at the plea issue separately. Thanks, Joe. So just the final thing, and this is to figure out, if the term is okay that I came up with. It was very early this morning, I think, when I came up with this term. So God knows what it, but whatever. So the term is voluntary standards to connote something different than our guidelines, but that when you're looking at the judicial proceeding and the court or the parties are thinking about concurrent consecutive or thinking about here's the aggregate sentence, should we be using county reentry? Should we be making the person eligible or ineligible for these correctional programs? That whole broad consideration. We're not making recommendations. We are providing sort of standards, and they're voluntary standards. They're not, but it's to put something in writing as a starting point. So again, I gave you about 20 different really bad terms, but I'm not sure what to use, but it was clear from, what we've heard from others is we want to have a distinction between what our guidelines are, which are the offense specific recommendations, and what these more general recommendations, suggestions are to the court. And so, I guess we can't spend forever on this, but at this moment in time, right now in the text is voluntary standards. We can modify this, and I can check with Professor Mystic. If sometime before we submit this, there's a better term that comes up and we can swap it out. I think that might be just a little textual thing that the professor will allow us to do. It's your call.
Well, I mean, standard to me sounds like it's something I have to do. That's not-
Right. Well, and that's why, no, I
Yeah.
get that. But I was thinking suggestions too, but suggestions seem like so,
Right. No, I get
like,
it.
so,
And I appreciate all the work you've done on this, Mark, and we certainly don't want to nitpick something like this.
oh, no,
I just, as soon as I saw the word standards,
yeah,
I immediately cringed because
Right.
standards, I mean, that implies something that if you don't do it, you're
Yeah.
not adhering to the standards.
totally get it. And in fact, Ryan and I talked before when we were going through like the thesaurus to try to figure out if there's a better word. We discarded standards because it sounded too structured, too like limiting. And so, the word voluntary was added as a little modifier. Judge, you have a,
So first of all, I like optional considerations because
Okay.
for whatever that's worth. However, is there a place? Because I think we need some more language. Maybe in definitions, where in one definition like we put recommendations and optional considerations,
okay.
and so that it spells out side by side
Yep.
what they are, because they're out there in different. So if we pull them together at some point.
Okay, absolutely. That makes sense. So it sounds like there's 2 votes for optional considerations.
I'd actually written down
Okay.
for Representative Kajewski before Dave said that. So I didn't.
How about-
forget
We
it,
give
so-
you that.
How about voluntary consideration?
I like voluntary considerations, but I.
Voluntary considerations? Going once,
take
going
either
twice? No. Okay,
I can
Vol-
live with either.
okay.
I'm not
Voluntary,
casting a deciding vote.
voluntary considerations.
That's
We appreciate your
Our new
attempt
term
at,
of art.
And then just somewhere we'll stick those two.
And we'll put the
terms.
2 definitions in the definition section.
But I would, my thought, again, is if you put recommendations in the R and then you go down to voluntary consideration, I would stick them in.
Right. So we'll come up with stuff the commission says and then the 2 different ones. Got it.
Sure.
We will.
I don't like the term stuff.
Yeah. Okay. Well,
You might-
voluntary stuff or no.
sort
Okay.
of along
I
the
get
line
it.
of decay.
you might need to put decay in there also.
Yeah. Okay. I think we're all done, aren't we? Okay. So thank you. If there are no other edits or suggestions, this will be before the commission, couple of hours for adoption, and then we'll be on our way to a January 1st implementation. So we're not done. We have 2 other sets of guidelines that we have about 10 minutes to get through. So the second one is our resentencing guidelines. And for the resentencing guidelines, we received no comments. And so I think, they're fine, except that one of the things that we should probably clarify is, since we've identified this new term, this administrative probation, is there anything different that we'd want to address about revocations of administrative probation that would be different than we have for other probation? At the very least, in this section, we'll insert the definition of administrative probation so that we have that in the resentencing guidelines. But the question is, if there's a revocation, we've been so focused on like limiting this thing so that it's only being used to like promote fines, restitution, and community service. I'm just wondering if there's a failure to comply with that and you have a revocation, are there any limitations on what we would recommend in terms of resentencing? So that's just, this would be the time to add it. If not, we'll just add the definition.
Yeah. So some of us talked about this last night in
Mhm.
our spare time.
We did.
And originally, my thought had been that we make it more narrow, but I think for consistency, we just follow same as what it is, technical violation, same.
Got it.
And then if there's a new conviction,
So
bump
it,
up.
would it be helpful to include the definition of administrative probation? I mean,
I think.
why not?
yes.
We have space. It's just electrons. So, okay, we will include the definition and make no other changes. And then the final thing is the recommitment ranges. And we reviewed this yesterday. And this is the changes we talk about. You can get to the last. are what we discussed with the board and with counsel for the board. And this incorporates just a handful of fairly technical changes, not really much substance in this. And it just is limited to the technical parole violations. We'll look back at the text just to make sure that if there's any modifications to the text, we capture the same thing. But I think the text just refers to this table, so we should make sure the table's right. So, so again, we've just inserted time served, and we'll define that somewhere, the TS, to take into account just the reality of the situation, and we remove the reference to maximum. So, unless there's any comments, that will be before the commission for approval as well, for adoption as well during the commission meeting. All right. I guess just to make sure we're checking all the boxes, could you put up the matrix? So this goes back to the sentencing guidelines, but just to show the matrix changes that we're proposing. It's very limited, but it just captures all the stuff we just talked about. So, so we can see, yeah, right there. We can see there at the far right-hand side, level D, where it's highlighted in the three below that, we've just replaced the statutory limit with a value. And then if we go up the page, you'll see that the ag-mid range is increased from 4 to 6 for level D and from 6 to 9 for level E. And then up at the top, we remove the reference to REVOC, and it's just prior record score 4 category. So those would be the only changes to the matrix. I will mention one other thing, and we've had discussions internally, and this is sort of policy versus automation and applications. But if you look at our OGS labels, they're all numbers up to 30, and then we have the special categories for murder of G1 and 2 for murder 3, so that's level G, and then above that, level H is for murder 1 and 2. And in another world where this was not sort of novel, we might just continue numbering 31 through 38 or whatever, and for computers that might be easier, but there's workarounds as well. So I just call that to your attention. We think there's some value from a policy point of view for new guidelines to distinguish these two categories as different, and to label them, especially because we're saying for level G, for murder 3, we want reasons reported in every case so that we can get a better handle on what's happening there. But I just call that to your attention that, at some point we might be coming back to you, some point in the far future, someone might be coming back to you, not me, to say, well, why don't we just convert this to numbers and it'll be easier. But I think for a rollout of this probably makes sense. So that was the final, very technical issue. With that, I think, unless there's anything else on the 3 proposals, I think we're set to go.
Mark, did we discuss the F3s from yesterday?
Oh, we did not. So yesterday during the discussion, we went through a lot of the OGS listings and assignments, and in the end, there were no changes recommended or discussed by the commission, but there was a concern or recommendations in testimony about looking at the felony 3 offenses, and especially those involving injury to persons, things like stalking, etc., that the felony 3 assignments would move up from a county jail recommendation to a state prison recommendation. So moving from level C to level D, and specifically to from OGS 9 and 10 up to OGS 13. As was discussed at the time, at least the data that we were looking at supports keeping it as a county sentence, because most of those sentences were around 3 or 6 months. But there was a policy discussion about whether for repeat repeat offenses like stalking or terroristic threats, things like that, or just when they're a felony 3, having a state sentence recommendation rather than a county jail recommendation may be warranted. So with that, let me turn it to the DA.
So, I took into consideration Judge McDermott's very well-reasoned thoughts on that issue. And so I think we might have a bit of a compromise here that I'm just going to throw out. So the proposal is, and I took notes on this, which is what I'm referring to here. I'm looking at. So my proposal is that there's a small number of F3s, okay? And those would be ones that are crimes related to vulnerable victims, interpersonal violence, and community safety, that they have, and I'll come to those specifically, that they would have a higher OGS than proposed, and that would be an 11.
Okay.
Now, although, and we went into great detail, and I give the commission such tremendous applause for the work that you did with the data to get to this point and explaining how we got to this point. And I would say that, there's a percentage probably between 10 and 20% of the cases that would end up with a state sentence for these specific crimes under, and we'll come back to that. And so we're looking at stalking, corruption, endangering the welfare of children, institutional sexual assault, and witness intimidation. And specifically, because there are some, and we went over this yesterday, there are some F3s that already have a higher range that would be a state sentence, specifically indecent assault. And if I'm correct, I think that indecent assault where the victim is less than 13, second or subsequent offense would be a 12 OGS. So all that being said, my thought is that an 11 OGS would be a good compromise for those specific crimes. If the individual would have a low prior record score, then they would most likely in most set of circumstances, that would be a county sentence. If a prior record score is higher, such as a 2, I would say, then it could include state time. And I think that an 11 OGS reflects the reality of these crimes and some of our current concerns and sentencing practices. So that's my recommendation, and we can take a deeper dive into that if you'd like to. But that was after much thought and reflection from Judge McDermott's comments of the commission in total. And so, very simply, as the DA on the commission, that's something that I feel strongly about.
That would not be inconsistent with the data because it would be a county recommendation, but it would allow with an enhancement of state and with prior record score, it would, but the starting point would be county. So that's consistent with, I think, what we were looking at, although the median might be a bit off. So if there is support for that, what staff could do between now and the commission meeting in an hour or so is just identify those offenses that are F3s and just recommend that those be increased to OGS 11 unless they're already unless they're higher than that already. And I don't know that we have many, but you mentioned one that might be an OGS 12.
Judge Marsico has a question.
Actually, for Sunday. So you're just talking about those offenses that you enumerated,
Yes.
stalking,
Stalking, corruption of minors, endangering the welfare of children, institutional sexual assault, witness intimidation.
the 5. So it'd
Those
just be 5 F3s,
Mhm.
and it would be moving out to Mark.
Up to,
That would move those from a 9 to 11.
right.
under
And
his
some might
proposal.
be 10s, but yeah,
Some might be 10.
we'd make sure that we're a 10. We're an 11 unless they're already at a higher OGS.
And the thought there, Judge, is that when you have someone who does have a prior record score of maybe a 1 or a 2, then we want the courts to have that option for a state sentence due to the interpersonal nature of that crime. That's my thought.
I don't have a problem with that, especially kind of give for the first offender it's a county sentence, which I think is what
Right.
the goal was. But then, whereas I guess if it stays a 9, even if you are a repeat, if you're even a 2 would still be county, even a 3
Yeah.
would still be county.
Sure.
So here it would give some leeway on those with prior records. I think we heard that in some of the testimony, and
We did. And I
different
think,
counties are different. It wouldn't affect my county that much, but I'm sure in some
Yeah.
different areas of the state.
and as we said before, we're using median sentences. So there were always sentences higher than that. There's always sentences lower than that. So there's a justification for having sort of easier access in some cases, and especially with prior record score to a state sentence.
Judge McDermott and then Judge Bernstein.
My concern is, and I understand the delineation of these particular crimes, and I'm certainly willing to give consideration to revising my position, but I have a question. If we really want to consider the prior record score, and give that jump to state time, why are we going all the way from a 9 to an 11? Because now we're in the category of F2s. And if I just put the chart aside and I say if the bulk of F2s are at 11, and the state legislature has said these are F3s, then I don't think they should be given the same category. Why jump to 11 instead of 10? I mean, to me, 10 might be the appropriate, because I'm looking, and correct me if I'm wrong, if you're talking prior record scores of, let's say, 3, you're getting into state sentences anyways, if the issue is, more punishment or appropriate state custody for those. But I would have to go back, since this is and look to see how many F2s are at 11. And the way I read the chart, the bulk of them are, unless they're gotten specified higher. So then I think we're in essence elevating the F3s to the same category as the F2s. And there's where my problem is, where I think we still have guidance that they're F3s, so they should be treated differently than F2s.
You want to respond?
A question I have with regard to the F2s are the bulk of the F2s. What are the OGS levels for the bulk of for F2s? What's the
Yeah.
range?
We'd have to look at that, but I think, the omnibus score is intended to be the default. And so there are occasionally F2s that would be lower than that, where the commission said, yeah, we know that's the default, but we're going to go lower. But I think the judge is right. A lot of cases, an F2 is assigned the omnibus, so it would be an 11, and then we build up from there. And so, and then, the same applies to F3s. There's, certainly the sort of the bulk of the F3s would probably be at a 9, but there are certainly F3s that are 10, and there are F3s at 11, I'm sure. And I think there's F3s below 9. So it's just that's the default that we use.
And there are F2s that are higher, right?
Yep.
Like, what are the highest F2s?
We'd have to look at that. I really, I don't want to give you an answer. I see,
15?
right away a 13.
Okay.
And I'm sure there may be higher than that.
And-
I see a 16 for aggravated indecent assault, unconscious victim, and F2 is a 16. So
Just
I think that's a crime of violence. So probably explain why it's so high. I see a 17 actually for ag assault, ag indecent assault, mentally disabled victim. So they can go higher.
So I guess two things is we do overlap with the default on other felonies if we wanted to take it to an 11, but for the practical application, if we moved it to a 10, you wouldn't hit state as a standard guideline until you're a prior record score of 3 or above.
Correct.
And if you bump it to the 11, then that brings you down one prior record score where you'd be state. But in either of those opportunities, you go with 10, very easy to swing up into the aggravated range. To make it state, if you go 11 for those higher prior record scores, if there's an outlying case, easy to bring it down into the mitigated. And I know people want to look at the standard. My point is it's a pretty small impact whether it's a 10 or 11. I understand that they are unique in that they're more severe than most others, and they're,
What,
victims
I don't
are-
know if this is helpful or if this adds confusion, but, if you look at some of our enhancements, for instance, there was a lot of comment about domestic violence along with these kind of offenses. And for domestic violence, the enhancement is +2. So if you think about, an OGS 11, where there's domestic violence, 0 prior record score, the domestic violence enhancement would move that up to the 13, which is state confinement. So, so the sort of some support for an OGS 11 for these offenses is with enhancements, any enhancement almost, it would move it into state confinement. But you'd get there with a prior record score if you were an OGS 10. So it's just, I know DV and some of those other violent gang related activities, things like that, sometimes are associated with some of these offenses. And so, just something to think about that we'd be adding to, in those circumstances to whatever the OG find.
And a quick question for Mark and also Jason as well. With 9 or 10, given the enhancement and also the aggravated range, would that already get into state confinement based on?
Yeah, so the
10%?
aggravated, that's a really good point. For 10, the aggravated range for an OGS 10 would generally be 3 months, plus or minus 3 months, unless the person was in I guess in a prior record score 3 or greater, where the increase would be 6 months. So at least for a 0 prior record score, you would stay in at 10, you would stay in county. And well, hold on a minute. No, for a 0 prior record score, you'd stay in county confinement. For a 1 prior record score, you'd go up to state, or you could with an aggravated range.
If I can just jump in, because I really would want to take a look at all of these, but I just happen to know exactly what the statutory, for that witness intimidation is a 4952.
Mhm.
So I pulled out the offense gravity score as an F3. It already is a 10.
Right, and that's what I was saying. Some of these
So
are,
some of them, so that's
Yeah.
the question I guess I have is, are we engaging in an exercise in which we don't need to because they've already been elevated?
well,
So
let's
I'd have
see.
to know, we could look them up real quick.
How about, maybe I could suggest this. I know we have to go into an executive session for another matter. And some of this is getting a little tedious, but maybe there can be some discussion with some members to try to see if there are certain offenses and agreement on an OGS that we can bring to the meeting, or we can continue the discussion during the commission meeting when we're moving to adoption on this. But I'm sort of sensitive. I know we have an executive session that we have to have, and I'd just like to get
Sure.
into that fairly soon.
Yep.
Thanks.
Would commission members be okay with us tabling that and perhaps having a offline discussion to bring during the
Yeah.
adoption?
And maybe Ryan could be available during the break and going into the one and in just reviewing the OGS assignments. If there's any question.
Okay. Well, if there's no other matters.
Maybe you could turn to Professor Mystic for an announcement regarding the executive session.
Yeah, the chair has requested that the commission go into executive session at approximately 10 o'clock. We're a few minutes past that time. The purpose of the executive session will be to discuss pending personnel matters. And at this time, I would ask that everyone leave the room, but for the executive director and the members of the commission.
Thank you.